correct. We now want to shift focus to a matter of national concern. All eyes today were in the corridors of justice as the High Court upheld the Senate's decision to impeach former Deputy President Rigathi Gachagua, dismissing several consolidated petitions that challenged his removal from office. And we did hear from the three-judge bench consisting of Justices Eric Ogola, Anthony Murima, and Lady Justice Freda Mugambi. And the court found that Parliament acted within the law throughout the impeachment proceedings and that the process met the constitutional requirements for public participation. The judges also ruled that allegations that Parliament lacked authority to consider impeachment due to failure to fully implement the two-thirds gender principle were unfounded. And according to the court, the issue did not deprive Parliament of its constitutional mandate to consider and determine impeachment proceedings against Gachagua. The bench also upheld the validity of the parliamentary standing orders that guided Gachagua's impeachment process, finding that the procedures used by both the National Assembly and the Senate were lawful. On public participation, the court found that the National Assembly conducted the exercise in line with the Constitution, further dismissing claims that the speakers of the National Assembly and the Senate, as well as members of Parliament and senators, were biased during the impeachment proceedings, with the court maintaining that the petitioners failed to provide evidence to support those allegations. So much was canvassed by that three-judge bench as they delivered their ruling on issues to do with constitutionality, on how that impeachment process was handled. Of course, the aggrieved parties have voiced that they will be heading to the Court of Appeal to appeal that particular ruling. That's Gachagua and the other petitioners who are enjoined in that particular case. But one issue seems to be sticking out, the issue that the three-judge bench found that Rigathi Gachagua's right to fair hearing was violated. Then that's why they decided to give Rigathi Gachagua 50 million shillings that's payable by the Senate due to that particular matter that is raising serious constitutional questions, that if the process was unconstitutional, how does its outcome actually survive? And that's why we have a constitutional lawyer right here in studio to perhaps take us through the legality or the legal jargons that came up during that particular ruling that will be appealed even as we wait for that particular process. I'm joined by Ivan Sndong. He's a constitutional lawyer. Karibu sana. Thanks for your time. Welcome to our studios.
Thank you, Jesse.
Okay, I'd like us to begin with the elephant in the room. Before we get to what this ruling means and the political and legal consequences of that particular ruling by the three-judge bench, talk to us about that right to fair hearing, because according to the three-judge bench, that's an issue that was in violation of Rigathi Gachagua's rights. But at the end of the day, they only gave 50 million shillings as a remedy. So I guess what I'm trying to ask is, what should be the consequence of rights to a fair trial that have been infringed upon?
You see, Jesse, today is a very sad day, and it is a sad day not for Rigathi Gachagua, but it's a sad day for the Constitution. Many times, the Constitution of Kenya has been tested, and our Constitution has been one of the most tested ever since 2010. You do not find a Constitution close to ours. Maybe you can talk of South Africa, you can talk of Malawi. Now, with the history that led us to 2010, where we got our Constitution, there are certain rights that the people of Kenya ring-fenced against any derogation. Those rights are found under Article 25. And part of those rights is fair trial and what is now commonly referred to as fair hearing. Now, if a court finds that your right to fair trial, unlike any other right, is violated, the recourse or the effect of that is that it is as though the action that was taken has been completely undone. It is as though it was not taken in the first place. Because all the other rights, Jesse, all the other rights under the Constitution lie and find their lives on the right to fair trial. it does not matter whether heavens fall. In fact, Jesse, on that right, a 5-judge bench already found that even in a case of terrorism and state of emergency, the right to fair hearing cannot be derogated. So what we saw today is what I would call 3 judges sitting as morticians to a right that you cannot touch.
So you do support the fact that this might have been a constitutional absurdity?
I think of greatest proportions. But let me get to the justification that they pose.
Yeah.
They pose a justification and they say that were they to find that the effect of Rigathi Gachagua not being heard would undo or quash the entire process of the impeachment, then we would end up with 2 deputy presidents and what they call a constitutional crisis under Article 145(7). Now, Jesse, Article 145(7) says that the finding of the Senate as to an impeachment of a president or a deputy president is final or shall be final. That finding of the court shall be final. And therefore they say, we found your rights to have been violated. Instead of undoing the entire process, we award you 50 million. If you read 145(7), the finality of 145(7) is the finality as to the merits. That if the Senate so wise that they would impeach Rigathi Gachagua for violating certain principles, that right is absolute to them on merit. But where there has been a constitutional infraction, nothing stops the High Court from adjudicating and undoing that violation. Now, if this was another right in the Constitution, or let's say privacy, the right to privacy, what the court has done today would be applicable, where they say, your right to privacy has been violated, we award you damages. But when it goes to the rule of natural justice, the court has no free hand. Once the court found that the right to fair hearing had been violated, the court had no option but to undo the effect of that impeachment. But what the court essentially did today, the court said, we do not want to contemplate a country with 2 deputy presidents. But you see, Jesse, Rigathi Gachagua in his amended petition already told us, I am not seeking for reinstatement. And that is why I'm here saying, we may not like Rigathi Gachagua, but we cannot butcher the Constitution in the manner the 3-judge bench did today. Because the next time, Jesse, the next non-derogable right, let's say the right not to be subjected to torture, will be violated by a state agency. And the court will use this precedence and say, look, although the right to fair hearing was non-derogable, the court awarded 50 million. Although you were tortured, let's say the police were looking for evidence to charge you, all we can do is to compensate because the crime that is before you, or the crime that you have allegedly have committed, is very serious. That is where the court has put us.
Okay, thanks for breaking it down, especially for the laymen out here who are trying to understand what exactly it means. So from where you sit, if the right to a fair hearing was infringed, then that whole process of impeachment should be thrown out in its entirety.
A total nullity, Jesse, a total nullity, for the simple reason. And the court actually explained to Kenyans. The court said, on the afternoon Rigathi Gachagua was to be impeached, Rigathi Gachagua fell ill. Now, the peculiarity of this, how peculiar this is that Rigathi Gachagua had no other witnesses in this matter. He was the sole witness that could attest as to the gravity of allegations and could face trial. Now, 2 things happened. The court does a very good analysis and say, all the senators who spoke that afternoon did not contest that Rigathi Gachagua was unwell. In fact, they wished him well. The speaker in the final communication when he was declining the adjournment told us that we wish Rigathi Gachagua well because health is beyond any human circumstances. But number two, the Senate had proceeded on the premise that they have 10 days. So even Saturday was available to them. Senior Counsel Paul Muite asked the House, why then can you just consider my client and give me a little bit more time and see if my client will get some relief? So it was not a violation where you say there were other witnesses to be able to speak on behalf of Rigathi Gachagua. But he was the only witness. That is why I'm saying this is not about Rigathi Gachagua. This kind of mortalization of the Constitution cannot be available. And let me just finish on that by saying, if at all the grounds will fail, this single ground of appeal, I am sure in my mind, will succeed.
Well, we'll see what the Court of Appeal decides on that, because we heard from Gachagua and the other petitioners, they plan to appeal. But I was listening to the court making its ruling on the right to fair trial, and it made it clear that it was violated, but they failed to reverse the underlying outcome of that unfair trial. From what you've argued, I get a sense of their hands were sort of tied due to the fact that things had progressed. We can't have two deputy presidents, even with the fact that Rigathi Gachagua wasn't seeking to be reinstated as a deputy president. So the court used argument under Article 145 that impeachment is a final process, and you've mentioned. So is the court trying to say the right of the High Court to look at any proceedings of a judicial or quasi-judicial nature is limited in the case of Article 145 of the Constitution? In short, their hands are tied.
And that would be the biggest absurdity of all kinds. Let me start this way. The court began on a very good footing. If you followed, the first issue that was before the court was, do you have jurisdiction to entertain an impeachment and be able to scrutinize an impeachment?
He said yes.
The court answers to the affirmative, and the court says, we do have that jurisdiction, provided that a claim on a violation of a constitutional right or the Constitution has been presented. And on that premise, the court says, we take jurisdiction. But the court did not stop there. The court goes ahead and says, we will not delve into the content or the merit of the impeachment. And if you recall, Senior Counsel Elisha Ongoya during the trial made extensive submissions on each of the grounds of impeachment upon which Rigathi Gachagua was impeached. The shares issue, the issue of shareholder, the issue of the comments against Justice Maina. But if you listen to the judgment today, the judgment did not delve into any of those issues, because the court said we cannot engage with the content or the merit of the reasons why the Senate did that. All we can do is to ask, in the process of so doing, did the Senate step on any constitutional right? Now, upon making that very solid finding, the court then goes ahead and somersaults. This is all I call judicial acrobats. It somersaults and says, here is the most of the prime rights of an individual, the ones you cannot touch. Actually, they even say that it is one of the rights that even if he was the devil, please hear him. He may be the devil, you have decided you want to, kill him altogether or mutilate him, but hear him. So the court, having gone on that premise, the court then somersaults and says, here is a right that has been clearly violated, but will not intervene. The effect of that, which is what you have asked, is this. The effect of that is this, is that the court has used Article 145.7 to destroy Article 25, which is not permissible in law. You can't use one provision to destroy another provision of the Constitution. You can't say you will only get this right. The court essentially was saying you can only get your right to fair hearing and, vindicated in the right manner as to process, only if it is not going to lead to a scenario where we have two deputy presidents.
Okay, now the order of reinstatement was withdrawn by the petitioner. That's clear.
Yes.
And it was called a constitutional absurdity when they got to the matter of doctrine, constitutional dilemma, saying they don't have a way of constitutionally finality of impeachment vis-a-vis violation of the rights of the petitioner. Please expound that for us. Can these two be separated?
Indeed, they can be separated. The court's hands and mind to be able to resolve the tension that appears between 145(7) of the Constitution that says the resolution of the Senate as to the impeachment of a deputy president or a president is final, vis-a-vis Article 25, was very possible. Look, Rigathi Gachagua, we begin from this premise. Rigathi Gachagua did not have to seek reinstatement. Provided the court quashed the process, the consequential effect would have been that the entire process that led to his removal is gone. That can be interpreted differently. Some people have interpreted it that what it would have meant is that he gets back into office. But there are two issues. Today we have a substantive deputy president. All the court would have done on the first instance is to say, although we undo the entire process and its legal effect is Article 75(3), which says if you've been removed, you cannot run for a public office. The best the court would have done is to say, we do not reinstate you in office because another constitutional process, that of the appointment and the vetting, the voting on Kithure Kindiki, which they found to have been compliant, and agree with them that the process was compliant, having taken place to its logical conclusion, all we can do is to make a declaration that Article 75(3), which tells us that if you have been impeached, you are not amenable to run for public office, cannot apply to you because the very substratum that led to the outcome is a nullity in law. So the court cannot even be heard to be saying that. But there is a second path that the court would have taken, even in the circumstances. Nothing would have stopped a court from saying, look, although it's disruptive, but it is possible because Article 23 of the Constitution allows the judge or the High Court to give appropriate reliefs in the circumstances. A party does not have to ask such reliefs when the court wants to fill some gap. The court would have simply said, look, the deputy president right now, Kithure Kindiki, is in office. But by the virtue of the quashing of your impeachment, you remain the substantive deputy president. Why? The deputy president, Kithure Kindiki, ought not to have been brought into office in the first place. Okay. That was a possible but a tricky route. So the second route becomes better for the court to have.
The one you had mentioned before. Yes. So isn't the Constitution supposed to be interpreted holistically, as you mentioned, in a harmonious way, that one clause or article does not supersede the other, to avoid an instance of contradictions, which it seems, according to your analysis, is what we're facing right now? What happens when the interpretation is done in such a way that it might bring further conflict? I guess what I'm trying to ask is, what issues will the Court of Appeal be looking at? You mentioned that the you mentioned about the Deputy President, Rigathi Gachagua, and whether he was put in office legally. The court said that's okay. In fact, public participation shouldn't have been conducted. But what are other issues, including this one that we've canvassed, that the Court of Appeal will be coming through with a magnifying lens to ensure that the rule of law and constitutionalism is not watered down?
Many issues, Jesse. But before I get to the issues that we are likely to see dominate the Court of Appeal, perhaps one more important thing. Remember when this process was going on, when Rigathi Gachagua came before this very bench and asked the bench, look, stop this process of the Senate from happening, because if it happens, it has a binding consequential effect. You might not be able to undo it.
This is when the impeachment was happening?
Yes.
Okay.
If you recall that ruling, this same bench was clear. The bench said, look, do not worry. Allow the parliamentary process to take its logical conclusion, because we will still be able to adjudicate and vindicate any constitutional infractions that come out of the process. The court assured Rigathi Gachagua during that time, and remember the stay was lifted, even in the final stay that was lifted that now paved the way for Deputy President Kindiki to be sworn in. They categorically said that. Today the court said, no, our hands are tied. Then you ask, if they knew their hands were tied, wouldn't it have been better then that at that time they preserve the quality of the Constitution by issuing the conservatory orders? But that's a different issue. To the Court of Appeal, two principal issues will dominate that court. The most glaring one is the one we have spoken about. The question of, are you able to find that somebody has been violated of his fair trial rights and then go ahead not to undo the process? Because the effect is natural justice. It is as though whatever happened did not take place in the first place. And now that Gachagua did not insist he wants to go back to office, who knows, even if the legal effect would have been for him to go back upon the quashing, he would say no because he dropped that choice. We would still be here with a constitutionally compliant country. So that is one of the limb. Are you able to restrict and derogate on a right that the Constitution says cannot be derogated? That would be one. And number two, and perhaps the most serious one, is Article 145(3)(b), where the court asked itself today, upon receiving the motion from the National Assembly, was the Senate to go plenary, or was it to go through a committee of 11 members? The court says, we have looked at the history of Article 145. It begins from the Bomas draft, it goes to the Wako draft, and it comes to the final text that found itself within the Constitution. And says, look, our interpretation, looking at the history of this matter, is that first, the Senate ought to have a resolution. When it receives the impeachment motion, it needs to look at it on the face of it. Does it disclose some charges or some grounds that call upon us to have an intense inquiry, resolution stage? So if, for instance, the president is to be impeached for wearing a yellow shirt, and the Senate says, no, this is not a ground we cannot sanction, the motion should be able to die at resolution stage. But if the court found, like it did now, that the grounds are plausible, they can call for some intense scrutiny and inquiry, the may in Article 145, the problematic may, Article 145(3) turns into must. So it will depend on A. If the resolution does not approve the prima facie, the charges, it dies. But if it does approve, then it has a mandatory duty under B to come up with a committee. The court says, this is our interpretation. Then what the High Court does, it picks a Supreme Court decision in Sonko, and it says, no, Sonko said as regards to impeachment of governors that the Senate can go through plenary, that committee of the whole House, or it can go through the committee route. Then the court says, with utmost respect, we respect the Supreme Court. Although we have found that this is the right interpretation, we are bound by the finding of the Supreme Court. That is problematic in two aspects. One, the same court is saying the impeachment of governors is distinguishable from the impeachment of the Deputy President and the President. That's the first problem. The second problem, they say that Article 145(3) is the same as what the Supreme Court was interpreting, Section 33 of the County Government Act. The problem is, the Supreme Court, what was before the Supreme Court was not what is the interpretation that should be ascribed to 145(3)(b). It is what in law we call obiter. Obiter is just those passing statements that a court can make in the process of adjudicating the main issue. Like today, you had the court say, let the National Assembly or the Senate pass this, kind of bill. It does not form part of a binding because, the court has no way of enforcing it. Okay. So there are those obiter and then the main holding. So those two issues will actually be of great interest, amongst others.
And I'm pretty sure our viewers back at home are now trying to translate what this particular ruling means in terms of the political implications. The court wasn't too clear on whether Rigathi Gachagua is legally bound to run for president or not. It seems to have left room for various interpretations, and that's where all the lawyers in the room come in, including land lawyers who are now legal experts. Talk to us about your analysis of this particular ruling and the political implications thereafter, even as we wait for the Court of Appeal process and perhaps the Supreme Court. Yeah.
Maybe I should start with how Sonko took place, because Sonko also engaged Article 753, which says an impeached individual cannot hold any public office. Any public office, whether appointive or elective, you cannot hold. So this is what happened. Sonko's impeachment went through the Senate. It was upheld by the High Court. It was also upheld by the Court of Appeal. Now, while an appeal was pending at the Supreme Court, Sonko decided to declare himself he wanted to vie for governor of Mombasa.
Yeah.
And you remember what happened. The IBC, no, we cannot clear you. Then Sonko went to the Mombasa High Court. And the Sonko said, no, there is no way you can fail to clear me when there is an appeal that is pending. Because, let me tell you just, Article 99(3) sets out mechanisms that when an appeal or a review is still pending, you cannot be removed under Article. When you are removed under Article, under Chapter 6, that removal cannot be bound on you when an appeal is still pending. If you looked at the grounds of Rigathi Gachagua, surely it was predicated upon Chapter 6 on integrity, where they say he did this, he did that, but they all fall within the integrity of a public servant. The High Court told Sonko that IBC cannot buy you. Go and run. Sonko went and began a campaign. What happened then? Within 48 hours, the Supreme Court rendered a decision that sealed Sonko's fate, so he was not able to go the full hog. But were it not that the Supreme Court determined that question within 48 hours, Sonko would be a governor today. What does that
if
say?
He won, yeah.
If he won,
yes,
if he won. Let me get back to Rigathi Gachagua. The strict, plain reading of the court today is, as we sit here, Rigathi Gachagua cannot run. That is what the court has determined. He can't run because the court has said your right is violated, but that does not take away the impeachment, which means he stands impeached at Article 75(3) and cannot hold any public office. That is a plain reading for anybody that watched the proceedings.
But he hasn't exhausted. Okay, proceed.
That would be the plain reading
yes.
of anybody that was watching the proceedings. But we know for a fact, that is as of now, because an appeal has not been filed. Immediately, Rigathi Gachagua lodges a notice of appeal to the Court of Appeal. Article 99(3) kicks in. Rigathi Gachagua will vie tomorrow. It doesn't need a stay. You know, I've seen some people arguing that it needs a stay. It doesn't need any stay. Provided an appellate mechanism has been set into motion, you are eligible to vie.
So if things proceed this way and the Supreme Court hasn't pronounced itself, let's say in the case where Rigathi Gachagua fails in his appeal at the Court of Appeal,
yes,
and he proceeds to the highest court, the apex court,
yes,
and they haven't pronounced themselves, the 7-judge bench hasn't talked on that matter,
yes,
he's still bound to vie.
He will vie. He will definitely vie. Actually, the only difference with Sonko... Okay, you see, this is not something open to interpretation because Article 99(3) is clear. I've seen some people say that Article 99(3) only applies to members of parliament, but that is an erroneous reading. Indeed, it talks about a member of parliament. But remember, the same constitution says, if you are to be eligible to vie for presidency, you must qualify as a member of parliament, which means Article 99(2) and 3 applies in the similar manner because IBC must first ascertain that you are qualified to run as a member of parliament. That's when you will be cleared to run for presidency. So in this case, even if the appeal at the Court of Appeal is fast-tracked and the Court of Appeal agrees with the 3-judge bench, which is unlikely in my view, but in the judicial process, it's a matter of you never know, wait and see. If they do that, and Rigathi Gachagua appeals further to the Supreme Court, I can guarantee you that if he wants to run in 2027, he'll be on the ballot.
Let me throw a spanner in the works. What if he's been cleared to vie, he's on the ballot, and that's when the Supreme Court perhaps agrees with the High Court and the Court of Appeal in terms of upholding his impeachment?
A possibility that was not contemplated in our constitutional framework. But this is my view. Just say it is always common practice that a decision will only take effect as at when it has been given. It cannot interfere with actions before then. But I see two things.
Yeah.
One, assuming Rigathi Gachagua is cleared, he vies and wins presidency. Let's take such an ideal scenario. I can guarantee you that he'll run the full term. The reason being, and eventually the Supreme Court finds that he was rightly removed from office, he'll run the full term. Yeah. Two reasons. One is the fact that you remember BBI. The Supreme Court told us you cannot sue a president, a deputy president, a president, under any circumstances, whether in a civil process or in a criminal process. So even if somebody wanted to go to court to challenge his occupancy of office, he'll not succeed because you cannot sue the president as a personality, as an individual.
What if he's given the running mate ticket? Can you sue the deputy president?
Well, that is still not clear because you see, the Supreme Court in BBI tried to avoid that question. They tried to avoid that question. But then they say what is not expressly provided is excluded. So there is a possibility. What is not expressly provided is basically excluded because the Constitution only refers to the president.
Okay, there's a saying that is repeated time and time again that justice must not only be done, but must be seen to be done in terms of the process, in terms of the substance. So as we finalize this discussion, Wakili, at the end of the day, was justice served? What's the ideal situation if justice was served?
Just before I came to the studio, I was interacting with some teachers of law in law schools. And this is what you call a pendulamic judgment. A judgment that even those who are following, it swings far left and you think you are almost close to heaven, and then it returns you to the earth and back again to, like I was saying, the former deputy president was swinging between Wamunyoro and Harambee Avenue and IBC offices in Nairobi for clearance. I think it has created a lot of confusion. You need a judgment that is internally coherent for such a serious. So, because you see, there is also the place of public perception. There is somebody who was watching that and, is listening and is saying, oh, your rights have been violated, but we are sorry, we cannot undo the process upon which, you are meted such kind of actions. So I think my short answer would be, today, there was no justice. And like I said from the beginning, this was a clear butcher of our Constitution. I think we must not allow our Constitution to be butchered in such a manner that the three-judge bench did.
Okay, we've delved into most of the issues, but a lot more was canvassed by the three-judge bench. Matters to do with public participation, allegations of bias within the National Assembly and the Senate, constitutionality and legality of standing orders, composition of National Assembly, the role of IBC, and the nomination of a deputy president. A lot was canvassed. But apart from these contentious issues that we've highlighted, what other issues perhaps have caught the eye of legal minds across the country in terms of the ruling, its applicability, and whether it served the intended purpose?
Definitely a lot more, and we may not even try and attempt to exhaust.
Yeah.
If you look at the manner in which the question of public participation was handled, and with utmost respect to the court, I think the court did a glossy kind of analysis where it does not want to deal with the real issues that were presented. Remember, there were affidavits before the court averring that there were bribery allegations of close to 10 million before this bench. You realize that the manner in which the court was dealing with the matters before it, the court was being too careful for itself. And you'd see that through every analysis. They set out the law, they say, this is what the law does, and then when they get to the facts, they avoid the germane issue. So the question of public participation, for instance, especially on the quantitative aspect, because there is the two sets, there's qualitative and quantitative. The court says 200,000 against the 55 million is sufficient public participation. However, for public participation, I will not blame the three-judge bench. I have always argued that the Supreme Court indeed gave a lot of power in the Okiya Omtata judgment on the finance bill. It gave a lot of power to parliamentary organs in terms of, the leg room of what they can, how far they can go in determining the issues of public participation. So I think perhaps this court was also just trying to apply the same to what was before it.
Okay.
Apart from the question of public participation, you recall that there was a very critical issue. The court says we cannot delve in merit. You recall the Mwangaza, the Kawira Mwangaza judgment. Justice Mwamue told us nothing stops you from delving into the merit, whether the charges were rightly framed or not. And the Court of Appeal, the same in Wambora, told us that. So I can assure you, I can guarantee you, perhaps the only question that will not make it on appeal is the question of perceived bias and the question of jurisdiction.
But the others will.
The others will. All the other grounds will.
And they'll be weighty.
And they will be weighty. But the two most consequential one would be the one on fair trial and the one of Article 145. So, committee or plenary route. So
we should keep an eye out for that. Well, Evans Nong, that's all the time we had. Thanks for breaking it down in a way that most of us would sort of understand this legal jargons, because a lot was canvassed in that over 10-hour ruling delivered by the three-judge bench, but a couple of issues seem to be standing out. And that's why we've been able to pick the mind of the constitutional lawyer in studio and perhaps get his thinking and his analysis on what the implications of this particular judgment is, even as we wait for that Court of Appeal process, which the petitioners and Gachagua's legal team have assured that they will be pursuing. Asante sana for your time. Hoping to host you again.
Thank you, Jess.
Thank you for breaking it down. That's how we've finalized on that particular conversation. And I'd like us to take a